Hello everyone, I'm Sadik and you are watching Legal. To get more information about legal topics and law subjects, like, follow, share and subscribe. So in the last class we studied about Article 12 which defines states. Now moving on towards Article 13, Part 3 of the Indian Constitution, it states laws inconsistent with the fundamental rights. Okay? What are laws inconsistent with fundamental rights? Those are against the fundamental rights or Part 3 of the Indian Constitution. Before understanding that, we must understand what are pre-constitutional law and what are post-constitutional law. Pre-constitutional law are those laws which are made before the constitution, and post-constitutional law are those laws which are made after the constitution came into force. Now, what Article 13 states that those laws which are inconsistent with fundamental right or Part 3 of the Indian Constitution are void to the extent of such inconsistency. But do the law completely becomes void or some part of it becomes void? That will be answered further in the video. The pre-constitutional law, if they are inconsistent with Part 3 of the Constitution, they become void to the extent of such inconsistency. If in a law there are 3 sections and only one section is against the Part 3 of the Constitution, then only that section becomes void. The whole law remains in force. But in post-constitution law, if a parliament passes a law which infringes or inconsistent with the Part 3, then the whole act or whole law becomes void ab initio. Void ab initio means void from the beginning. They will not come into force. As per these laws, they will remain in force, but as Part 3 came up, then if the whole act or the some part of the act is inconsistent, then that part or that whole act will remain void. But as soon there is made amendment in this part and that inconsistency is removed, the pre-constitutional law again come into existence and again come into force. So you are understanding? I'll make you understand more. Article 13.3 defines law. What are laws? So laws are basically laws which are made by parliament, the ordinances promulgated by the president or the governor, the law made by the state legislature, or rules, bylaws made by local authorities. These even custom and usage. I'll write it down. Law passed by legislature, ordinances, rules, bylaws, even custom and usage as a course of law as per the Article 13.3 which defines law. Through 24th Amendment Act, Article 13.4 was inserted in Article 13. 13 clause 4 was inserted in Article 13. What does this clause state? It states that Article 13 does not apply to amendment made under Article 368. That is, amendment made under 368 are not law. Hence, Article 13 would not apply to Article 360. So basically, it was to make the amendment procedure easier and also to make Parliament more powerful. But even if the amendment made under Article 368 can be made, but the basic structure cannot be changed. I hope now you have understood basic idea about Article 13, that Article 13 talks about pre-constitutional law, post-constitutional law, those laws which are inconsistent with the Part 3 or fundamental right, and Article 13.4 which talks that yet amendment made under Article 368 are not law. Article 13 can be seen as a tool of judicial review. What is judicial review? If a law is inconsistent, then who will state that the law is inconsistent? So the Constitutional Court, the Supreme Court and the High Court have the power to state that a law is constitutional or unconstitutional, whether it infringes or takes away your fundamental rights or not. If a pre-constitutional law or a post-constitutional law takes away or abridges your fundamental right, then the Supreme Court and the High Court has the power under Article 13 to strike down those parts of the law which are, or even the rule or the ordinance which are against Part 3 of the Indian Constitution. So Article 13 gives power of judicial review, which is to review the laws in contravention to Part 3. Which court has the power to exercise judicial review? The Supreme Court and the High Court have the power to review those laws which are made by the Parliament, or the pre-constitution law, the post-constitution law. If they are to the extent of inconsistency void, then the High Court or Supreme Court may struck down those laws. Now we know what is judicial review. Now there are two processes or two procedures to exercise judicial review, which are asked in many examinations, and they are very important and also very logical. The first thing is doctrine of severability. I'll explain what is doctrine of severability. It can be also called doctrine of severability. Okay? That means to separate, to sever, to cut. In the doctrine of severability, as we understand, that as I told you, that pre-constitutional law and post-constitutional law are only void to the extent of inconsistency. If an act has, for example, 3 sections, and only part of the section or subsection is violative of fundamental right, then if that part can be severed without changing the whole structure of the act, and then after severing, after removing or after separating that part, that becomes consistent with the fundamental rights, then that law can remain in force, but that only that part which are inconsistent can be removed. This is known as doctrine of severability or doctrine of separability. We separate those parts which are against the fundamental right or part 3 of the Indian Constitution. The whole act do not become void, only those parts which are void to the extent of such inconsistency with the part 3, only those becomes void. A very landmark case, A.K. Gopalan versus State of Madras, in that Section 14 of Preventive Detention Act was held to be inconsistent with the fundamental rights, and that part was removed and the whole act remained in force. In State of Bombay versus F.N. Balsara, only a part of a section of Bombay Prohibition Act was against, or you can say inconsistent with Article 19(1)(f). So that section was removed and the whole act remained in force. In A.K. Gopalan versus State of Madras, Section 14 of Preventive Detention Act was held to be inconsistent with the Part 3, which is violated of Article 14 of the Indian Constitution. Hence, only this section was removed and the whole act remained in force. Only this Section 14, to the extent of inconsistency, was held void. Same in the State of Bombay versus F.N. Balsara, Section 13B of Bombay Prohibition Act was removed as it was against Article 19(1)(f). Only this section, the particular section, was against Article 19(1)(f). So the court tried to remove Section 13B, and it was held that rest of the act remains in force. Only the part which was void against, or which was inconsistent with the fundamental right or Part 3 or Article 19(1)(f) was removed. The whole act remained in force. So this is doctrine of severability. If you have any queries, please write in the comments. The other method through which the court applies Article 13 or judicial review is through doctrine of eclipse. We all know that there is solar eclipse and there is lunar eclipse, which means eclipse means to hide. So in this case, it applies to pre-constitutional laws. So as we understood that pre-constitutional laws remains in force even after the constitution come into force. But if those laws are inconsistent with the fundamental right or Part 3 of the Indian Constitution, they get eclipsed. They do not be void ab initio as post-constitutional laws are. They remain in force, but to the extent of such inconsistency, they are eclipsed. As soon as that inconsistency is removed, or if the amendment is made in Part 3 or the amendment is made itself in the Act, then it continues to remain in force. Understand it like this. There is a pre-constitutional law. There is a pre-constitutional law. Now, laws are in force and they are running. Now, the constitution came. We know 26 November 1949, the constitution came into being. Now, these pre-constitutional law, after coming of the constitution or Part 3 of the constitution, if they are infringing, if these laws or some part of this law is infringing the Part 3, then that constitutional law will become void. If some part of the act is infringing on Part 3, then that part will become void. If the whole law is infringing on Part 3, then whole act will become void. But if an amendment is made, in this pre-constitutional law, and after the amendment is made, then these laws do not infringe on part 3, then that act continues to remain in force. Or if an amendment is made here, if the amendment is made in constitution itself or part 3 itself, and after making this amendment, then these laws do not infringe on that fundamental right or part 3, then also these laws will continue to remain in force. So this is doctrine of eclipse. Eclipse means it only hides those laws for a time period, till that it only hides those laws till the extent of inconsistency. As there is an amendment in the act itself or in the constitution or part 3, then if the amendment is not infringing on your fundamental right, then the act continues to remain in force. If you do not understand any part which I discussed in this video, you can again watch the video and pause where you don't understand. I hope it will be clear. If you have any queries or any doubts, you can ask in the comment section. Bye.